Right, recording started. Just give it another minute, and then we'll get going. Okay, well, it's 2 minutes past, so I think we should get started. Obviously, I'll keep an eye on the waiting room and bring in anybody who joins after we've got started properly. So, good afternoon and welcome everybody to this. I think this is the 10th one that we've had this year, Foyle Island learning event. I'm absolutely delighted to have Fred Gilligan here with us today. This is the second event that Fred has done for us, so we're very grateful to him for the time that he puts into these. We are recording, but that's simply so that we can produce an accurate write-up that we can then distribute to anybody who's not able to join us this afternoon. So this event is called the New Occupiers Liability Act and Discovery in relation to post-accident medical records. Two, I would think, quite separate subjects, and I'm not quite sure how Fred's going to handle them. We haven't rehearsed it, but I'm more than happy really just to pass over to you, Fred, if you're happy with that, and let you take the floor from here.
Thank you very much, Lawrence, and thank you everyone in Foyle for having me back. I mustn't have been that bad the last time. I'm going to talk to you about two things today. I probably could do a paper on both of these, an hour, or certainly 45 minutes each on both of these topics, but I'm going to do my best to get through them. I'm going to start with the post-accident discovery paper, and then I'm going to look at the new Courts and Civil Law Miscellaneous Provisions Act 2023, which is the act that's been introduced to amend the Occupiers Liability Act. That's a pretty fresh piece of legislation. It was only enacted on the 31st of July of this year, so we haven't really seen any effects of it, but it kind of comes on from a couple of cases which I'm going to talk about. But I'm going to start with the discovery paper, first of all, and I'm going to really focus this paper on the case of James Egan and Castlereagh Cooperative Livestock Mart Limited. And it's a decision of the Court of Appeal from July of this year. The High Court case was what everybody was referring to as the Toomey decision, and nobody really knew the name of the case, but everyone was just saying the Toomey judgment, the Toomey decision. So that's where this case, that's where this talk really comes from. And at first, when people read the decision of Justice Toomey in respect of post-accident medical records, nobody felt it would stand up to scrutiny in the Court of Appeal, because obviously traditionally in Ireland and this jurisdiction, post-accident medical records and the discovery of post-accident medical records has only ever been available where a plaintiff has suffered an accident after the index accident and suffers an injury after the index accident, or in the alternative, where there's a very, very close proximal time limit to a previous injury and then the accident itself. And traditionally, the courts have always said, look, with regard to post-accident discovery, the plaintiff doesn't have to discover the medical records, because the defendant is always entitled to have the plaintiff examined by their own medical expert. And of course, you'll all be familiar with the case of McGrory in the ESB, where the Supreme Court held quite some time ago now, and I'll come back to this in a moment, but they essentially held, look, medical experts are entitled to talk to each other for the purposes of, a defendant expert can speak to the plaintiff's treating doctor and can review operation notes or anything like that. And so there was no need for post-accident medical records discovery. So what happened in Egan was the plaintiff was attending a march on the 13th of November 2017, obviously in Castlereagh, and he alleged that he'd been standing in a designated safe area when a bullock collided with his left leg, causing him to sustain personal injuries. He issued a personal injury summons in April 2020, and a defence was delivered shortly after that in the usual way. Within the particulars of personal injury, and this is quite important in the context of, and I'm going into a little bit of detail on it. Within the particulars of personal injury, he pleaded that while this accident was obviously to do with his leg, he had received in 1999, he had been involved in a road traffic accident and he had sustained injuries for which he had received compensation. And he also disclosed in the particulars of personal injury that he had an L4, L5 disc bulge and had undergone spinal surgery in the 1980s. So we're going back quite a bit of time there. He delivered updated particulars of personal injury along the way, and essentially they referred to a consultant orthopedic surgeon as having carried out investigations of the plaintiff's left lower limb, including an MRI scan of his lumbar spine, which showed a compression at the L5 nerve root. So having pleaded that, the plaintiff, I suppose, opened himself up to the pre-accident medical records in respect of discovery of pre-accident medical records. And they sought 5 years pre-accident records to ascertain the state of his back and the health of his back prior to the accident, the subject matter of the proceedings. And initially, they also sought 5 months post-accident records. And the reason they gave for that was to examine, and I'm quoting, to examine to what extent, if any, there was an overlap of complaints from the previous medical history and the injuries allegedly suffered in the index accident. And the letter of voluntary discovery from the defendant also pleaded or stated the availability of these medical records will allow a comprehensive medical examination of the plaintiff. And then the letter went on to finally state that the documents would establish the extent to which the plaintiff's injuries and ongoing treatment as a result of the accident overlapped with any pre-existing or subsequent injuries. Now, and then it went on usual pleadings that it's relevant and necessary and everything else. And in one sense, yes, it sounds like a well-pleaded letter of voluntary discovery, but in another sense, it's worth just remembering it's not particularly specific. It's not saying these documents are absolutely crucial for a doctor so-and-so to examine the plaintiff. But nonetheless, that was the reason that was given. So in the High Court, the matter came on for hearing before Mr. Justice Toomey in the High Court. And initially, the plaintiff agreed to the first part of the category of documentation. Sorry, is there a question? No, sorry.
I think if somebody came in with their mic on, Fred. Very good. Just a bit of background noise.
Apologies. So the plaintiff agreed to the first category of documentation. The plaintiff agreed that all documents in respect of treatment for any back or leg pain or symptoms from 1 January 2012 up to and including the plaintiff's initial medical attendance post-accident, but nothing thereafter. So the matter came on for hearing before Mr. Justice Toomey, and he ordered discovery not only of the pre-accident medical records, but also of the 5 months post-accident. And he noted in his decision that this was in order to keep the plaintiff honest in pursuing his claim for personal injuries. So that was a relatively unhelpful comment in the context of it. But he had taken that sentence from the Tobin and the Minister for Defence, and I suppose he had slightly twisted it to come across as fairly cynical. He went on to observe that post-accident medical records are in all reality more likely to be relevant to the proceedings than not, because they evidence the injury sustained in the accident, whereas the pre-accident records clearly will not do so. And then Judge Toomey also dealt with the argument put forward by the plaintiff that discovery of post-accident medical records is not necessary because the plaintiff will at a later point in the proceedings be obliged to provide copies of medical reports that he seeks to rely on at the trial of the action. And Toomey rejected that argument because essentially he said, look, post-accident medical records are the best evidence. They are a contemporaneous note of what the plaintiff was enduring, what he was undergoing, and the treatment he was receiving. And as we all know, a plaintiff can easily go off and get a medical report from a doctor, either a treating doctor or a medical legal expert, and then decide, well, I don't like that report, and I'm not going to rely on that report, and the defendants will never see it. So I can see where Justice Toomey was coming from in that regard. He concluded that post-accident medical records are not just relevant, but invariably they're crucial to every personal injuries claim. And he then proceeded to grant discovery of the plaintiff's post-accident medical records for a period of 5 months. The plaintiff appealed to the Court of Appeal, and Miss Justice Butler in the court on behalf of the 3 judges, she gave the decision in July of this year. And in the first instance, she considered the Tobin case, which is obviously Tobin versus the Minister for Defence, and Clark, Chief Justice Clark, as he was then, his decision in that case. And she took the view that post-accident medical records are not inconsistent with that. And she made the comment, needless to say, personal injuries cases do not form a subset of litigation in which the parties, much less in which the plaintiff especially, are inherently disposed to being dishonest, and therefore are in particular need of being kept honest. So I suppose she noted what Mr. Justice Clark had said, and in a sense, I think she was probably a little bit critical of Judge Toomey and the wording that he used as a reason for granting post-accident discovery of post-accident medical records. She went on to consider a decision by Mr. Justice Brian Murray in the Court of Appeal from 2020, which is Mix Wallace, a minor, and Dunn. That's 2020 IEC A282. And I have a written note of all of these, and I'll circulate it afterwards if you want. These reasons include assisting the parties and in ascertaining of the facts in cross-examination, opposing witnesses, and enabling the parties to fully and properly instruct expert witnesses as to the subject matter of their evidence. So that, therefore, is a good reason now for post-accident discovery, to allow the defendant to instruct its experts fully, and also to allow the plaintiff's, I suppose, barristers prepare fully for the cross-examination of the plaintiff's own experts. Within the judgment of paragraph 20, she noted that the plaintiff had had a previous accident, and she then went on to deal with the issue of privilege and whether or not post-accident medical records are privileged. And she very succinctly and deftly set out the test there, and said, of course, a medical report would be privileged because a medical report is produced and created in contemplation of the litigation that has probably at that stage already started or is just about to start. However, medical records are not privileged because they are documents created, notes and records created by the treating doctors for the purposes in the course of their profession as doctors, and as a professional obligation that all doctors have to keep good notes. So those are not created in contemplation of litigation, and therefore medical records in and of themselves are not privileged. She noted the well-established theory that the right to privacy that a plaintiff would ordinarily enjoy falls away when a plaintiff brings a claim for personal injuries, because of course at that point in time the defendant is entitled to seek discovery and of the plaintiff's medical records pre and post accident. The defendant is entitled to examine the plaintiff. The defendant's medical experts are entitled to speak to the medical experts of the plaintiff and can review notes and records of relevance to allow them form a full opinion. So, and in that regard, she referenced the decision of Chief Justice Keane in McGrory and the ESB. And she noted, but Miss Justice Butler noted there that McGrory was not a discovery case, but rather concerned the entitlement of a defendant not just to have the plaintiff medically examined, but to be provided with the names of the plaintiff's medical advisors so that the plaintiff's case could be discussed between the defendants and the plaintiff's medical experts. In holding that the plaintiff was obliged to disclose the medical records to the defendant, the Supreme Court relied upon the decision of the Court of Appeal, the English Court of Appeal in Dunn v British Coal Corporation, which held that a defendant's medical examiner was entitled to examine the plaintiff. And Chief Justice Keane specifically stated in the Supreme Court in McGrory, and it's quite an important paragraph, the law must be in a position to ensure that he does not unfairly and unreasonably impede the defendant in the preparation of the defence by refusing to consent to a medical examination. Similarly, the court must be able to ensure that the defendant has access to any relevant medical records and to obtain from the treating doctors any information they may have relevant to the plaintiff's medical condition, although the plaintiff cannot be required to disclose medical reports in respect of which he's entitled to claim privilege, legal professional privilege. So McGrory, I think we're all probably familiar with McGrory, but it's a case that's worth drilling into, and it's particularly a case that's worth drilling into in light of the Egan decision. Miss Justice Butler also in Egan considered Power and Tesco, which was the decision. It's kind of a heavily relied upon decision on a common law motion list of a Monday now, where it was just Mr. Justice Barrett did away with the idea of post-accident medical records being discoverable on the basis that simply the plaintiff could be examined by the defendant's experts. And that decision, I think Power and Tesco has now largely fallen away as a result of this Egan decision, and that's worth bearing in mind. There was another case of McCorry and McCorry, which is a 2021 case, decision of Mr. Justice Simons, and he concluded that it was reasonable to assume discovery of post-accident medical records would assist in demonstrating which of the plaintiff's complaints were related to the accident and which related to other pre-existing medical issues. So in that case, there was pre-existing medical issues not necessarily linked to the index injury, but yet Mr. Justice Simons said, well, I'll provide discovery of pre and post accident medical records so that the defendant can ascertain which symptoms relate to which injuries. So that's another decision worth sticking into your back pocket or into your war chest for discovery applications, and bearing in mind that there's a little bit more scope creeping in for defendants with regard to how we go about looking for post-accident medical records. So in reaching a conclusion in the Egan case that discovery of post-accident medical records was relevant, Miss Justice Butler considered at length the relevance and necessity test, and she sets that out in over maybe a series of 10 or 12 pages in the judgment. But I'm not going to rehash that here because we don't have time. But the judgment in that regard is worth reading. She also considered, and I think this is something which is important for us as defendants to bear in mind when looking for discovery, this new situation which is arising more and more frequently, and as a defence to discovery, that the request is too onerous and burdensome. And oftentimes when we think, well, look, you're only going to be discovering a very limited amount of documents, and therefore it's not necessarily onerous. But in fact, it's not so much the documentation that the plaintiff is going to discover, it's the search pool, if you like, of documentation that the plaintiff, or indeed his medical advisors, his GP, whatever, has to search through for the relevant documentation. And what we all see nowadays is everything is really on computers, and everything is vast amount of information. You know, I certainly remember when I started at the bar not so long ago, that we were, you'd get medical GP records, and you'd be lucky. It would be might be scraps and notebook pages with illegible writing on it, and sure they'd give it over to you, no problem. But now, if you get a set of GP records, it probably runs to maybe 20 or 30 pages. They're detailed, they're all typed out, and it is such a helpful tool for cross-examination. I'm going to come back to that at the end of this talk, but it also means there's a lot of work to be done, because the plaintiff's lawyers, or indeed medical assessor, has to review those documents. And if you have 30 or 40 pages of medical records from a GP, and we all know it takes a few hours to go through it, from the point of view of finding which appointments related to the plaintiff's back and which didn't, and then redacting the ones that you can redact or whatnot. And then, of course, you go into a more complicated plaintiff cases where there might be a crossover of injuries or a multitude of injuries in the one case. And again, what's relevant and what's necessary, it's not necessarily what's going to be churned up to the defendant on the affidavit of discovery at the end of the day. It's actually the process that you have to go through. And if you've got volumes of medical notes and records to go through, that can be difficult. And there is a significant amount more documentation being kept now. All of this, so much information being held on plaintiffs across the board that possibly has to be searched and makes up the search pool for these discovery requests. With regard then to a summary of the principles that Miss Justice Butler set out for discovery, she first of all said, once accepted, and I'm summarising from her judgment here, once accepted that the plaintiff's post-accident medical records are relevant, this raises a presumption that the discovery was necessary for the fair conduct of the proceedings, and the plaintiff has to rebut that presumption. So once it's relevant, it's for the plaintiff to rebut the presumption that it's necessary. A failure to reply to a request for discovery means that some arguments put forward by the party of whom the request is made may be created in an evidential vacuum. And we are seeing more of that creeping in as well, where judges, particularly, I suppose, without naming names, maybe judges who have come from the commercial end of the profession, or judges who would have been sort of chancery lawyers, and they're coming across this, they're hearing common law motions, they're hearing long discovery applications in the non-jury list. They're sort of thinking, well, where's your replying affidavit? And well, you can't say that, it's not an affidavit. And it becomes tricky. So I think what Miss Justice Butler is saying here is you really have to reply, and this goes for defendants as well, when replying to plaintiff's request for discovery. If you want to make arguments at a hearing, you need to set those arguments out on your reply to the letter of voluntary discovery. It's no longer acceptable, I suppose, to simply write back saying refused, too broad.
Hi, Jane.
No,
Yeah.
Look at these, right?
not a good reason, or whatever
It's
it is. And it's also, I suppose, it's a suggestion that maybe the plaintiff and or defendants in opposing these applications may need to give just a little bit more consideration to swearing affidavits of replying affidavits, setting out the reasons, particularly if a defendant or a plaintiff is saying that something, the search pool is going to be too large and it's too onerous and burdensome to search that search pool, then in reality that has to be on replying affidavit. And not only that, it has to detail out what the situation is. I'm doing a case for the state at the moment, and it's tormenting me. It is a huge element of discovery, and the plaintiff is requesting discovery across a number of government departments. And I'm saying, well, look, this is far too broad. We need to say this, it's too onerous. And the instructions are difficult to get because the people aren't necessarily coming back and saying, well, look, if you run such and such a search term through the system, you'll get 5 million hits and 3 million documents, which might be relevant and will have to be considered. And really what the courts want to see is they want all of that information, and then they want things like the man hours that will be required to search it, why it's so difficult to search, the methods you're using to search it, search terms. So there is detail required if you're putting up that argument. Another important point in the Egan case was a significant reason as to why post-accident medical records were relevant was due to the evidential indicator of the overlap of injuries. So even though the plaintiff hadn't suffered any post-accident injuries, there was clearly an overlap with regard to his back injury, and that opened the door for the defendant to seek the post-accident medical record. So the evidential indicator of the overlap in injuries, stick that into your letters of voluntary discovery, that phrasing from now on. Butler J rejected the proposition, as I've already said, in Powell and Tesco. Butler J rejected arguments that because the defendant would be provided with medical reports that are going to be relied on by the plaintiff in advance of the trial, that this negated the need for discovery. She rejected the argument that because the defendant is entitled to have the plaintiff independently assessed and examined, discovery of post-accident medical records is not relevant or necessary. She stated that the fact that an issue may be the subject of expert evidence at the trial does not, in her view, preclude the possibility that discovery of documents relevant to the issue may be properly sought in advance of the trial. She rejected the proposition that some or all discovery material would be provided at trial and therefore there's no need to make discovery. That's going back to the argument that I suppose it's already out there. You already have those documents. That's not necessarily correct, and it doesn't get you it doesn't get the plaintiff or indeed the defendant away from making discovery. She also rejected, I suppose, in a sense, or certainly sidelined to an extent, the Tobin decision, which is all about which was that decision about the interrogatories, and everyone for a while decided interrogatories were going to be the next big thing. But in fact, she did it. She details out a couple of paragraphs on this in her judgment, and she really says, look, interrogatories in a personal injury case aren't particularly useful because of their very nature, the kind of the yes or no answer nature of them. They're not particularly useful. And then she noted the analysis of Toomey J in the High Court was correct in its decision to allow discovery of post-accident medical records, and in particular, she endorsed the reasons advanced by Toomey J. And that's all. That analysis is set out in paragraph 19 of the judgment of the High Court judgment. So, just a couple of general observations from me on post-accident discovery. The first is your letter of voluntary discovery. They do have to, the reasons have to be detailed. The categories have to be defined. We know that, but I do think it's important that your reasons for seeking voluntary discovery are well set out. And if there is to be a reference to a previous accident or a subsequent accident, all of that needs to be set out clearly in the reasons for the discovery. And it's important to note the overlap between accidents, the overlap in the recovery. And I think Simon's decision in Macquarie is really helpful as well, because it says, look, the plaintiff might be suffering from a sore back. One is due to the pain radiating from his neck in a different accident, and one is from the lower back pain he sustained in this accident. And as such, we need to find out where the pain for the purpose of these proceedings is coming from, and therefore the post-accident and pre-accident medical records are relevant. In my personal experience, and certainly in the circuit court, GP notes and records, the more you can get, the better. They're hugely beneficial, and they're a brilliant tool in cross-examination of a plaintiff. RTA dismissed last week because the plaintiff, who had a number of medical reports from eminent medical legal experts, had only visited his GP once and had no report of his GP, and we managed to get post-accident medical records, and he visited his GP once for the purpose of the accident, and then on four or five other occasions for a cough and a cold and a sore throat or whatever else, totally unrelated reasons. And it was very, very fertile ground in cross-examination, because it made him, why are you going to your GP with a runny nose, but you're not mentioning your sore back? Why is that? And it puts the plaintiff in a difficult position. The medical records, as I'm sure you all know, specifically in particular, the initial attendance can be very helpful from the point of view of ascertaining the exact circumstance of the accident. Also helpful in ascertaining if there was alcohol or drugs taken or anything like that. That's all helpful from the initial attendance. And then, of course, Toomey J had a lot to say on this in a different case, but it's worth noting. It's always certainly, if I'm doing a plaintiff case, I'd always say to don't refer the plaintiff to an expert, to whoever it might be. If he's going to go to an expert, he should really be with it. It should be his GP who's referring him or her, because it doesn't look good if the solicitors are referring. And all of that comes out in post-accident medical records when you see the solicitors, the plaintiff's orthopedic surgeon writing straight back to the plaintiff's solicitor, rather than writing to the GP or writing to his treating doctor. It's not, there's nothing necessarily wrong with it, because the courts have since held a solicitor is entitled to seek an expert medical view. But I think it looks much better for a plaintiff if they're being sent to that orthopedic surgeon or that psychologist or psychiatrist, whatever it is, by the treating doctors such as a GP or whoever it might be, and not the solicitor themselves. So I'm going to leave the Egan decision there. Look, it's 29 pages. It's not the longest judgment in the world. it's worth looking at. It really is. It's a really helpful guide as to what we can expect to get in the discovery process going forward, particularly with regard to post-accident medical records. They're so helpful to all of us in defending plaintiff claims. You know, there's so many interesting little features and nuggets of information that we'll pick up in the post-accident medical records. They're really helpful, and this is certainly this is going to be helpful from the point of view of defendants defending cases, personal injury cases going forward. What I might do is I might plough on with this, and I might go into the Occupiers Liability Act and the amendments.
I just wondered, Fred, if anybody had any particular questions on disclosure at this stage before we move on to what I guess is quite a separate subject. Anybody got any questions on medical reports and disclosure? You can always put them in the chat if you want, and I can feed them back into Fred. No, okay, all right. Please, let's get on to the Occupiers Liability Act.
I've opened the chat, so if anyone does have any questions, you can type them in and I'll see them popping up. Excuse me. So the next thing I want to talk to you about is it won't be as long, but it's the Occupiers Liability Act 1995 and where we are going with the new amendments to the Act that have been brought in courtesy of the Courts and Civil Law Miscellaneous Provisions Act 2023. And that was signed into law by the President on the 5th of July 2023. And essentially it provides provisions which are, again, the subject, I suppose they stem from the defence side of the house to try and reduce the fairly onerous obligations that were imposed upon defendants and I suppose insured people and clients with regard to the occupiers liability. So there's a couple of things I'll summarize briefly. The first thing is occupiers have a duty not to act with reckless disregard for recreational users or trespassers. So the new act is going to raise the threshold for holding an occupier liable on grounds of reckless disregard. So previously, an occupier acted with reckless disregard where they knew or had reasonable grounds for believing a danger existed on the premises. Under the new act, an occupier is only deemed to have acted with reckless disregard where they knew or were reckless as to whether the danger existed. That's a very substantial change. So, you know, that's certainly moved the goalposts somewhat. Another change that's coming through, and I'll refer to a bit of case law in a moment that this sort of stems out of, is the extent of the duty of care. And the Act now limits the extent of the duty of care owed by an occupier towards an entrant. And it looks at a number of different features that we are a test in many ways that are to be looked at and used as an assessment of a defendant's obligations. In assessing whether an occupier has complied with their duty of care towards an entrant, regard will be had to several additional factors, including the probability of the danger existing and the injury/damage being suffered as a result of it. And there are so many different cases that I'm sure we've all been involved in over the years where, you know, the poor uninsured is sitting there with their head in their hands and, you know, what can we do? It was a wet day. We put the mat down. You know, how are we to know this mat will only absorb X amount of water and thereafter it'll become slippery? Or, you know, how are we to know all these sort of things? So that allows a defendant to say, look, it was improbable that the rain that day was going to be so heavy that it would damage the mat, or it was improbable that the floor would, with a slip resistance of X, would reduce itself to a slip resistance of Y when it became wet. The other thing, which is kind of a counterbalance to that, is the probable severity of the injury and damage if suffered. So I suppose it's sort of saying how dangerous was this risk? And what was the risk of a serious injury occurring? And I wonder, will that be interpreted in due course to sort of suggest, look, if you have a far more a more severely damaged plaintiff, you're going to end up having to pay out because the injury was more severe. It's just it's the wording is unusual, and it'll be interesting to see how it's interpreted. There also, giving consideration in the new act, to practical and policy-based considerations, such as the cost of taking preventative measures and the social utility of the conduct. And that again, I suppose, is quite important, because I certainly know I represent a number of, the large independent retailers, and they frequently have their heads in their hands with regards to, look, we are spending hundreds of thousands every year on signage, on mats, on wet floors, cleaning systems, everything else. At what point in time can we just say we've done everything we can do? And I think now that's going to be something to look at in defending an occupiers liability case. We had spent X amount, we could not have done any more. And again, that we'll have to see how the judiciary interpret that. A key change that's been introduced is to the voluntary assumption of risk. The occupier no longer has to show, he doesn't owe a duty of care to visitors or recreational users who voluntarily consent to and understand the risks. And that is a fairly significant development. And I think a lot of the leisure industry will be very happy to see that. I had a case in Limerick High Court in the last sessions 2 or 3 weeks ago, where a guy had gone on a stag party to a mountain biking place in Tipperary, and as he was coming at the end of the day in the last run, he came down a red run, which is kind of an intermediate, and he shouldn't have been on it, but he went up to the top, decided he would do the red run, came down at high speed, and the very last ramp, which was kind of a big rolling ramp, he went meters up into the air, landed on his shoulder, and suffered a very, very nasty break and injury to himself. But ultimately, the case didn't run. In fact, he withdrew the case, partly because we were standing over. Look, you signed the waiver, you were given a full introduction into the event, you knew that there was a risk involved, and I think that this act, the new act, is going to set that kind of argument into legislation. So people like mountain bike parks and other places where there is a risk involved in activity, they are going to be delighted to see this act coming in, because it will give them a defence that you can say that the voluntary assumption of risk, which never really properly existed in Ireland before. I don't think it was there, but it wasn't there, and the courts rarely upheld it. But it will now be in the new amended Occupiers Liability Act. Also, and quite significantly, and this arises out of the case, I'm sure you're familiar with, Byrne and Arden Heath, but on the issue of the legislation, the court is now entitled to assume, and the occupier is entitled to assume, that a plaintiff and an entrant can look after themselves in the ordinary course and can take reasonable care. Now, that probably won't apply to minors, to children, but it'll certainly apply to somebody entering a premises. And if you're familiar with Byrne and Arden Heath, it's a decision of the Court of Appeal, and the plaintiff took a shortcut from the defendant's car park to a nearby footpath, and she went down a grassy bank and slipped and suffered fairly severe injuries. And I think it was Mr. Justice Barr in the High Court awarded her damages, but reduced it by 40% for contributory negligence. And the defendants appealed that to the Court of Appeal. Miss Justice Irvine, it's a 2017 decision, Miss Justice Irvine held that the High Court had fallen into error, and that in fact a visitor such as the plaintiff, who is wearing unsuitable footwear and descending a damp grassy bank when there was an alternative exit, could not be said to have taken sufficient and reasonable care for herself. And on that basis, the appeal was allowed, and the plaintiff's claim dismissed entirely. And it's many of my colleagues are suggesting that decision, in fact, is probably possibly the driving force for the new act, because it is a change in the law. It doesn't necessarily apply to claims that are employer liability claims, where the employee plaintiff includes a plea for the occupier's liability, because I think an employer still has a duty under the health and safety legislation to provide a safe place of work. But that duty that is a different level of duty now to the ordinary entrant who's just who like Miss Byrne took a shortcut. She has a much higher onus now in legislation as well as a common law to take care for herself. A court previously was also entitled to award damages to a recreational user or indeed a trespasser who entered a premises for the purpose of committing an offence, where it believed the award to be in the interest of justice. And this is one of those really, I suppose, Irish things. Some guy comes into your house or climbs over into your back garden with the intention of robbing your house, and he puts his foot through a drain or he trips and falls, and he sues the homeowner. The new act will restrict the occupier's liability in this context to only in exceptional circumstances, and having regard as to the nature of the offence, the extent of the occupier's recklessness, or the fact the person was not a trespasser. So I still don't think we're allowed to set traps for thieves in our garden, but we may well now be, there's much more protection for an occupier from someone who enters your premises. That is going to be interesting as well, certainly from a number of my clients' point of view, with regard to, say, supermarkets, where somebody comes in with the intention of committing an offence and then suffers an injury. Well, then that would make it difficult for them to bring a claim home. Obviously, though, it strikes me it's a fairly risky case to run to say, oh well, Mrs. O'Brien came into the shop for the purposes of robbing us, and then she slipped on a grape and fell. Because in reality, if someone does come in, if you make that argument and it's not successful, you're exposing yourself, I would think, to aggravated damages. Another case which has seen a number of people have suggested is relevant to the new legislation is a case from 2020, which is a High Court case, Mulcahy and Cork County Council. And that's a minor case. The minor plaintiff was injured when jumping between boulders. And the High Court held in that case that the social cost and the burden on occupiers of eliminating all features from public area should be taken into consideration when a process proceeded to dismiss the plaintiff's claim. And that's what I told me earlier on. What has come in the new act is this thing. Look, you can only do so much, and you can only spend so much money. And if a defendant is doing everything they can, and it can show the court that is going to be very, very helpful. With regard to the new act, there's a number of different sections and subsections which are going to be inserted. You will see them. You'll see them in the 2023 Act, the Miscellaneous Provisions Act, and then obviously I think at this stage the 1995 Act, the amended Act, should be available to review. But the big sections are Section 4.3, Section 5A, and Section 5A, and then also to look at some of the earlier sections, Section 2, where to see where these changes are coming in and how they're being brought about. So that's really all I'm going to say. That there isn't a huge amount to work with on the occupiers liability because it's very, very recent, very, very new. But certainly the case of Byrne and Artheath and Mulcahy and Cork County Council are two very helpful decisions, and they're certainly worth having a look at in the context of where this act is going to take, how this legislation will be applied across the board in the High Court and in a Circuit Court level as well, obviously. So are there any questions on occupiers liability?
Fred, hi, it's Louise Boughton here.
Hi, Louise.
Just hi. You may have said it, and apologies if you did. When is the new act effective from, the Occupiers Liability Act?
The President signed it into law on the 31st of July 2023.
Yeah.
I'm not actually sure if it's technically commenced at this moment in time.
Okay.
I think it is.
But it'll only apply to accidents from. I mean, I couldn't apply it retrospectively.
No, but you've got the case law. It'll depend on the circumstances. You should look at Byrne and Artheath, and look at Ardenheath rather, and look at Mulcahy and Cork County Council, the minor case, because they are now. Mulcahy is 2020, IEHC 547, and Burn and Arden Heath is 2017, i.e. CA 293.
Okay.
They're both very helpful decisions with regard to the occupiers, you know, the duties on occupiers,
and would have been decided under the 95 Act, but ultimately
Yes.
are the precursor for this new Act in 2023.
Exactly. Yeah,
okay.
yeah,
Okay.
exactly.
Yeah. Cool. All right. Thanks.
Fred, I'm not sure if you can see this or not, but there is a question in the chat from Brian Strahan, which is about post-accident discovery.
Yes, I see that.
You see that?
So,
yeah.
Brian, to answer your question on that, no, I think 5 months is very light. And in fact, Judge Toomey in the High Court decision commented on that. He said, you know, I'll give you the 5 months because it's all you've asked for. But in reality, you would probably be entitled to more. So yes, it'll be case by case, but certainly I think there's huge scope there for decent chunks of post-accident medical records to be obtained. Certainly in all the letters I'm doing now for voluntary discovery, in the last paragraph of the reason for medical pre and post medical records, I'm referencing the Egan decision, and I'm saying, look, this is the request for post-accident records is made in light of, or it takes cognizance of, the Egan decision of Judge Butler, and I'm setting it out that way because it is helpful. But I definitely think there's big scope there for much more detailed notes or records. Are there any other questions?
Nope. Okay, well, listen, thank you everybody for coming along, and thank you particularly to you, Fred, for a very excellent talk, very well presented on two quite different subjects. So appreciate that. We've kind of got two for the price of one there. So thank you very much. Appreciate it. And I don't know if you're prepared to come back for a third time, maybe next year, but
I certainly will. Louise Boughton, on her question, the Act was commenced on the 31st of July.
Okay,
year.
thanks.
So that's worth noting.
Great. Thank you, Fred. As always, thanks.
Sure, pleasure.
So thank you again, everybody. I don't think we've got any more events lined up for this year, but we're already talking about events to come in January next year. So please do keep an eye open for invitations to those, and wish everybody a happy Christmas.
Yes, indeed. Happy Christmas, everyone. It feels like a day early to say it, but let's say it anyway.
Well, it's 1st of December tomorrow. We're nearly there.
Thanks, Lawrence.
All right.
Thanks,
Thanks, everybody.
Thanks,
Thank you.
Thanks, everyone.
Bye.
Bye.
Bye.